Welcome to this live-streamed webcast coming to you today from the American Council on Education at 1 DuPont Circle in Washington, D.C. My name is Peter McDonough. I am the Vice President and General Counsel of ACE. The topic is the Federal Fair Labor Standards Act and the Department of Labor's long-awaited final rule revising key aspects of its overtime pay regulations. The conversation is presented to you by ACE in collaboration with CUPA HR, the College and University Professional Association for Human Resources, NASPA, the National Association of Student Personnel Administrators, and Ballard Spahr, a national law firm with Philadelphia roots and long service to higher education. We thank many of our Higher Ed Association co-sponsors, which have led to nearly 1,300 registrants for today's webcast. As I suggested, the format for these 90 minutes will be conversational and informal. There will be no PowerPoints. Several timely webinars have been done on this topic and may be accessible to you, such as webinars by CUPA HR and NACUA, the National Association of College and University Attorneys, and the U.S. Department of Labor's Wage and Hour Division. Also, viewers can link to a 7-page ACE issue brief on the right side of your screen for this broadcast. Joining me today as panelists are Rosie Phillips Bingham, Barbara Carroll, and Stephen Suffless. Since 2003, Dr. Phillips has served as the Vice President for Student Affairs at the University of Memphis, a public institution with 20,000 students, where she has been since 1985. Earlier this year, Barbara Carroll assumed the role of Associate Vice Chancellor and Chief Human Resources Officer at Vanderbilt University, a private university with 12,000 students, coming to Vanderbilt from North Carolina State University, where she had the same role for 11 years. She is a current board chair for CUPA HR. Steve Suffless is a partner in Ballard Spahr's Labor and Employment Group, the managing partner of the firm's Denver office, and the former managing partner of its New Jersey office. Recognized by Human Resource Executive Magazine as among the nation's top 100 employment lawyers, he is also a prolific presenter on employment and labor topics, including wage and hour issues. Before we jump into this topic of the day, a couple technical comments for the viewing audience. First, our conversation is informed by questions and issues that the four of us have encountered during the last several weeks. However, you will note a feature on your screen that permits you to type and submit real-time questions that may come to mind during this broadcast. An off-screen ACE colleague will be reviewing them and presenting them to us for possible inclusion in the discussion. Second, this event is being recorded and archived online, and it will be available in approximately 1 week. You will be able to find the archived version on the event page from which you access this stream. Now to the subject that has led 1,300 folks to register for this on a Friday in June, and many others likely sitting in a conference room around the country with the registrants. Steve, could you frame our discussion by way of a brief summary of the FLSA and the final rule? And importantly, by noting and explaining a few of the key words and phrases that we will be using today.
Thank you, Peter. I'm going to start with a legal overview. Some of these concepts are very basic, and many, if not most of you in the audience, probably are already aware of them, but I want to make sure that we're all on the same page to start. I'm also going to start with 2 disclaimers. Number 1, we're going to be talking about the federal law under the Fair Labor Standards Act. Remember that the FLSA sets a floor, not a ceiling. And in every state, there are minimum wage and minimum hours statutes, which may be very different than the FLSA. So it's very important for each of you to also consult with your state law authorities in the locations to make sure that you're in compliance not only with federal law, but with state law as well. Disclaimer number 2 is I am a management side labor and employment lawyer. My career has made me cynical. When it comes, and I apologize for that in the start. In the wage and hour space, in terms of dealing with the United States Department of Labor, that cynicism comes from the fact that I've seen many employers victimized by illogical DOL action, by well-intentioned but misguided actions, by impractical and inept actions, and sometimes by misspirited and mean-spirited actions. So, and also I'm going to try to get a cheap laugh every now and then, so I apologize for that. Let's begin with very basic principles. Number one, the FLSA requires that overtime be paid for any hours worked in a single work week in excess of 40. Payment must be made at time and a half of the regular rate of pay. That is called non-exempt status. Employees eligible for overtime are non-exempt. Conversely, those who are ineligible for overtime are called exempt. The three main exemptions are called the white-collar exemptions. They are the executive, the administrative, and the professional exemption. For each, there are three criteria to be met in order to qualify for the exemption. Number one is salary level, and that's going to get a good bit of attention in just a moment. Number two is salary basis, and number three is job duties. So, in terms of salary level, we're going to talk about that when we talk about the new rule in just a minute. When we talk about salary basis, that means that the employee must receive a uniform salary each pay period that cannot be reduced for most reasons. So, for example, absences, not enough work to do, someone's sent home, the salary basis cannot be reduced. As for the particular job duties that apply for each of these three exemptions, for the executive exemption, this is for basically supervisors. It is people who supervise two or more subordinates. Their primary duty is management, and they exercise authority by way of hire, fire, discipline, assign work, etc. The administrative exemption is a different one. That deals with office or non-manual work that is directly related to the management or general business operations of the employer. Administrative employees must exercise discretion and independent judgment in carrying out their job duties. Finally, there is the professional exemption. This is where the job requires knowledge of an advanced type in a field of science or learning that is ordinarily acquired through a prolonged course of specialized intellectual instruction. It also covers individuals involved in artistic or creative endeavors, such as ballerinas. Other exemptions are important. There is one for highly compensated employees that we're going to talk about. These are people who perform some but not all of the duties of the executive, administrative, or professional classifications. Also, there is an exemption for computer-related occupations. For the computer employee exemption, those workers must be paid a guaranteed salary at the new rate of $913 a week, and we'll talk about that in a minute, or an hourly rate of not less than $27.63 per hour. Their primary duties must be involved in the design, development, creation, system analysis, etc., with greater definitions in the FLSA regs. For higher ed purposes, there are a number of job classifications that we should talk about right at the start. Number one, teachers. Under the FLSA, bona fide teachers are exempt from overtime pay, provided that their primary duty is involved in teaching, tutoring, instructing, or lecturing in the activity of imparting knowledge at an educational institution. This would include in higher ed, professors, adjunct instructors. The salary level and the salary basis tests do not apply to teachers. So the new rule minimum, again, we'll talk about it in a minute, of $913 a week, does not apply to bona fide teachers. Within the teachers exemption are athletic coaches. The DOL has been very strong in this area, especially in the face of the new regs. This requires instruction of student athletes in their sports. If the coach's primary duty is recruiting, performance analysis, other issues like that, the exemption may not apply. As for adjunct instructors, provided that they fall within the teaching exemption, they also are exempt. Full-time faculty members, adjunct or part-time instructors will not be subject to the salary basis or the salary level test. The teacher's exemption is not applicable to postdoctoral fellows, provided that they are primarily involved in conducting research at a higher education institution after having completed their doctoral studies, and who do not have a primary duty of teaching. Now, these individuals will likely meet the test for professional exemption, but the salary level and the salary basis criteria will apply to postdoctoral fellows. There is also an exemption for academic administrative employees under the FLSA. These are individuals whose primary duty is performing administrative functions directly related to the academic instruction and training of students. This may include department heads, academic counselors, advisors, intervention specialists, and others with similar responsibilities. For the academic administrative exemption, the salary requirement is either the salary level under the new rule of $913 a week, or a level that is equal to the entrance salary for teachers employed at that institution. And we'll have more discussion about that. For other folks in the academic higher ed realm, for non-student residence hall directors, if they are exempt, the employer may take no credit for room and board. If they are non-exempt, credit may be taken if the primary beneficiary of the room and board is the employee, not the employer. In other words, it's not required. The employee must also voluntarily agree, and there are record-keeping requirements in order to take that credit against the wage. For student residential assistants, if they are enrolled in the school in a bona fide educational program, they are not employees for purposes of the FLSA. For student research assistants, if they are conducting their research under a faculty member's supervision in the course of obtaining an advanced degree, they also are not employees. The same applies for grad student teaching assistants. However, the National Labor Relations Board, in the space of union organizing, is looking very closely at grad student assistants, and I personally believe that in the near future they are going to declare them to be employees for purposes of the National Labor Relations Act. Open question as to whether the Department of Labor will follow suit for purposes of the Fair Labor Standards Act. One question that came up as we were preparing these remarks, and that is, what are the rules regarding on-call workers? The simple touchstone is this: are they engaged to wait, or are they waiting to be engaged? And today, with increased technology, cell phones, messaging, so long as the individual can enjoy normal functions, basically do whatever they want in their off-duty hours, and are simply responding when called, the on-call time is not compensable. If they must be in a defined location physically so that they can respond, then the on-call time is compensable. Let's talk about the new overtime rule. For higher ed, this is going to have substantial impact on your budgets, on your programs, and on your HR functions. The rules were published on May 23rd, and the effective date is December 1 of 2016. The Department of Labor has opined that this is giving every employer affected ample time to come into compliance. As you'll see from our panelists' observations, this is going to be a challenge in the higher ed space. The new overtime rule changes salary level, deals with non-discretionary bonuses, and the other big change was automatic updates. So, effective December 1, the pre-existing salary level of $455 per week has been more than doubled to $913 per week, which translates to $47,476 per year. The reason for this was that in 2015, for a family of 4, the prior level was below the threshold for poverty. Highly compensated employees, the number will raise from $100,000 to $134,004. Don't forget the $4 annually. Non-discretionary bonuses, if paid quarterly, can make up to 10% of the salary level requirement. The other big change is that the salary level will be indexed and reevaluated every 3 years. So beginning January 1st of 2020, an automatic increase in the current $913 level. The standard salary level will be updated to equate to the 40th percentile of weekly earnings of full-time salary workers in the lowest area census for wages, which currently is the South. Highly compensated employees are going to be pegged to the 90th percentile. Let me close with this thought. The Department of Labor in the final rule says that 4.2 million workers in this country are going to be affected by this change. And by the way, I'm sorry I forgot to mention this. If the salary level threshold is not met, then these workers must be paid time and a half overtime for all hours worked in excess of 40 in a work week. So 4.2 million workers are going to be affected either by having their salary increased or by now receiving overtime pay at a rate of time and a half. The Department of Labor opined that the final rule will transfer income, and that is the quote, transfer income from employers to employees to the tune of $1.2 billion. The cynic says the DOL doesn't view this as an expense to employers. This is simply a transfer of income. I will also tell you that in the 161 pages of the new rule, nothing is said about where the money is going to come from. Peter.
Thank you, Steve. Well, there's a lot there. For many who are joining us from their campuses today, they already had an appreciation for that. For a few others, there's a gulp or two. How big a deal is this? What are the sorts of staff and faculty positions that could be challenging to deal with? Rosie, you oversee a broad umbrella of services and positions at the University of Memphis. Mm-hmm. Are there staff that you can imagine being impacted in surprising ways or ways that are just challenging as we think about how we'll return to our campuses in September and conduct the businesses that we've been conducting in the ways that we've grown accustomed to conducting, and that, frankly, many staff and faculty are looking forward to conducting that way?
Mm-hmm. I think it is a big deal for my university as well as my colleagues around the country who work at larger or smaller places as well as community colleges. So in student affairs, we would be concerned with people in residence life, people who are in Greek affairs, sororities and fraternities, multicultural affairs, people who are learning specialists or tutors, and in other areas that aren't necessarily mine, but in admissions and recruitment and financial aid. We have a large number of people who will not quite make $47,476. A lot of our people will probably make $35,000 or $45,000. And so, and some of those people work a lot of hours. People who work in residence life sometimes have been considered 24/7 individuals. That has to change. And so we will need to look to see how much it will cost us, whether or not we can raise some people, or whether or not we'll have to pay overtime. And quite frankly, we didn't get any more money to do the work that we've been asked to do in changing to the Fair Labor Standards Act. I'm not opposed to the act even because I think it's a good thing for people to earn more money. It's just how do you manage it and how do you get it all done? And so, for example, with someone who is an assistant director in a residence hall who lives on campus, and while not always having to be in the apartment, there is a certain amount of we're expected to be there. Now, we already compensate for that by having those people have an office. And we will say you don't have to come into that office until 9 o'clock, and maybe you can go home at 3 because we know that you will be working in the evening sometimes. We have to become a little more accurate about that if we're going to have people do that kind of work, or we have to move them up. So it will be a big deal. I think a lot of people are concerned about what does it mean and how will I get my programming done. We expect to be there to serve students in the daytime, and then we expect to come out for the programs they have in the evening. How do we manage all of that? For some schools, it might be wise to just look at all the positions, and some have even said, it's really cheaper for us to just raise everybody. It doesn't sound like it on the front end, but because of the number of hours they put in, overtime gets to be entirely too expensive. So I'd say, yes, it's a big deal.
So I've heard some folks say, well, not much has been changed by the final rule. There's some floor levels of salary that have been raised for exemption purposes. Not much has changed. Yet I've heard others worry that some colleges could literally be forced to shut their doors because of this. Barb, you've got a national perspective from your Coupa HR leadership perch. Do you have thoughts about this?
Well, in some ways, both of those things could have some kernels of truth in them. In some ways, as Steve described, not much did change. So the duties test didn't change. The salary basis test didn't change under the law. A lot of the underlying guidance provided by the rule didn't change from prior guidance. What changed was essentially this salary threshold, and it changed a lot. So it changed by more than 100%. What that will mean for organizations is that positions that they never really had to think about a whole new group of positions will be swept in for consideration. And for organizations that, like Vanderbilt, it's not going to put us out of business. We will figure out ways to do this. For organizations that are, trying to stay in business and trying to continue to provide student education and, maybe in rural communities, maybe small schools, this could have some pretty significant impacts if it's going to hit a lot of previously exempt but not highly compensated positions. So I think that each institution really is going to have to take a look at where they sit with regard to the salaries that they're paying and do a pretty in-depth analysis and figure out how either they can afford to increase salaries or to begin paying overtime or to limit services provided or lay staff off to pay for other staff. So I think there are going to be a number of pretty complicated considerations campus by campus.
So I have a process question for all three of you. It's late June. Many on the campuses around the country have taken a little bit of a breath. They have a work plan for the summer. They have vacation plans for the summer. The process question. On campuses, who should be discussing and deciding how to go about thinking about this and analyzing this? And who should be discussing, recommending, and deciding where a particular campus ought to be on what I'd call the risk spectrum, balancing this new set of obligations against existing programmatic expectations in a budget context where most folks have submitted their budgets, had them approved, and are planning to follow through on them, yet with a recognition that come December 1, the world has changed. Process. How do we do this?
May I start as the practitioner in the crowd? Because I see that at least 2 or 3 levels exist. One are people, some of whom report to me, who just have anxiety about it. They're just worrying about it. They haven't started to talk about it. The other are our HR and legal people who actually have begun to talk about this and begun to say, what is it that we need to do? What we have to do is draw everybody into the conversation. And of course, the executive team who really wants a great recommendation from the folk who are doing it. So we need to get those people involved in the conversation who actually do the day-to-day work. We need to see what those jobs mean. What are the duties in that job? Those people have to talk because they've got to wonder and worry about, this is what I say they do and this is how much time it takes. Can we still do it? So they need to be at the table to help the HR people understand something more than the title, what is there. our HR people and our legal people are experts. That's why I love being here next to Barbara and Steve, because they know what the law says and what it means. And they aren't the anxiety people like some of us are. All of those people have got to be in a room because we've got to find the truth. We've got to be able to know exactly what they do, what the budget would look like if we had to raise all the staff to the appropriate level, or what kinds of levels we have to change people to if we say we can't manage the overtime, or if we can do overtime, here's where our limit is. So all of us have to be at the table, and we have to bring those people in. The other group of people really will be those folk who will be impacted because there will be some psychological consequences to what will happen on our campuses.
Go ahead, Barbara.
I couldn't agree more. It takes a village on this one. I think people shouldn't wait for HR to tell them what to do. This is not an HR only issue. It will involve provosts. It will involve chief financial officers. It will involve student affairs leaders, because each of the areas of the university are going to be impacted, and maybe in different ways. Academic units may be impacted somewhat differently from administrative units. What we've found on our campus is that we've begun pretty in-depth engagement with leaders across campus in the various areas, trying to talk through what the scenarios look like and how they might impact different units differently. We're probably not going to implement across-the-board attempts at solutions. We have found it, I think, to be advisable to really look at almost position by position to make sure that decisions are the best decision for that particular scenario. So it will involve, done well, it will involve many constituents on the campus, from managers, employees themselves, you're right, up to senior leadership.
And there's a crucial role for legal in this. The FLSA is an unforgiving statute. And I always begin my wage and hour presentations by saying, if you have a workplace rule or practice or policy, and if it is logical, reasonable, rational, if the employees are happy, if the employer is happy, it's illegal. The FLSA in many ways is counterintuitive, and it certainly is counter common sense. One of the key factors, and I'm sure most in the audience already know this, but it's really important, employees under the FLSA lack the legal authority to waive their statutory rights. So, on the University of Memphis, if someone's being paid $40,000 and they say, Rosie, don't raise me, I love my job, I love the school, I'm an alum, this is where I want to be, this is what I want to do, don't worry about it, I'm completely happy. That is of no legal effect. That employee, if not paid consistently with the new rule, has a legal claim which cannot be waived. And because the other great challenge in this area is the wage and hour laws have been on the books since the 30s. As Barbara said, nothing changed with the new rule. The numbers changed, but in terms of the duties test, in terms of the examples, nothing changed. The problem is, in that regard, nothing has changed for decades. And so you've got an evolving academic community where jobs are changing, roles are changing, and the regulations have been on the books for decades. So there is an important legal function to come in and say, let's study the regs, let's study the job at the table, in the village, as Barbara said. Let's pull this all together. But the legal perspective is going to be crucial.
So if I'm hearing y'all correctly, one starts with the presumption that everybody's non-exempt and entitled to overtime, unless there is a basis in the law informed by these regulations for taking the position that the person may be classified as exempt and not receive overtime. Is that a fair statement?
Yes.
Okay, so then we get to the next thing. Is it the employer who has, and in our case, colleges and universities, that essentially tap the employee on the shoulder and say, we dub you exempt, and that's why we're not paying you overtime. It's not for the, it's not a legal requirement, correct?
That is true, Peter. I mean, one example is tangential to the higher ed space. Registered nurses are exempt professionals. Hospitals do not have to pay overtime to registered nurses. Many hospitals do. They do it for morale purposes. They do it for retention purposes. They pay time and a half on top of a very high salary. So there is no legal requirement that you classify people as salary and deny them overtime. Frankly, I would expect Mr. Perez, the Secretary of Labor, would encourage everyone from the provost level on down to get time and a half over 40 hours.
Don't tell my provost.
Mine would like that.
But Peter, to your point, it is the managerial function to say, these are positions where we are not going to pay overtime. Now, can we make sure that these positions qualify for the overtime exemptions?
And then it would be the managerial role to essentially explain and defend that judgment. Is that a fair statement?
Yes.
That's correct.
And then we get back to this process. Okay, so with that in mind, I want to go back to the sundry categories that Rosie was mentioning a while ago. And I heard you talk about tutors, and I recalled, Steve, your reference to the academic administrative exemption, and my head said, I'm betting that exemption may apply to tutors. But then I heard you offer a few other categories. We talked about residence life, and we talked about, other types of folks that are in the typical umbrella of student life. And I'm wondering, does that academic administrative exemption apply? Are we certain one way or the other? What do we do about that this summer?
I would say that we are not certain, and I would say that some HR departments, along with their legal and along with the people who are involved, will have to make some decisions about that. And I think people can either go liberal or conservative. I would tend to be a little more conservative just because I don't want University of Memphis to have an audit. But on the other hand, we do have people who are learning specialists whose main job it really is to tutor. And in our case at the University of Memphis, we talk about student learning, and we have a philosophical stance that students really should be learning from almost everything we do in student affairs, and that it should be supporting the academic mission of the university, or we probably ought not to be doing it.
Right.
So for example, people in campus recreation, we know that the data tells us that if a student uses that service even once, they're more likely to be retained and graduate, and that's what we want them to do, and we are teaching them some skills. So what do we do with the person who is the lifeguard or who teaches the classes there? There's a teaching function even though they aren't classified as a teacher. Or the Greek affairs staff member who really does have to even do classes with the students on legal liability or on running an organization or being a leader or teaching and doing intervention. So how do we classify those people, and do we use that rule to apply to those individuals? My colleague Barbara might think one way and I might think another, but I think that's why it's important for us with HR to look at the actual duties that individuals perform to see if, in fact, even though I think that, the university is willing to say, yes, we dubbed that true.
Yeah. I do think that a lot of institutions really are trying to be deliberate and planful and thoughtful about this idea of marrying curricular and co-curricular activities, and where does one stop and the other start, and where's the work that falls within this definition. We have a few examples from the Department of Labor, but it's not an exhaustive list. I don't think we'll get an exhaustive list. So I think it will be up to entities to begin to kind of sort that through in their own minds and make some risk decisions about do we think we can make a good business case for exercising that exemption on this kind of job, and how far afield from that are you willing to get as an organization? I think those will be independent senior leadership decisions on, and it really is a risk analysis decision. There's not going to be a yes/no list ever provided at the federal level, I think it's fair to say. And you know, you won't know you've crossed the line until some institution gets dinged for having crossed the line.
Yeah, that's a very wise comment. I mean, in my opening remarks, I recited all of the guidance that higher ed has received. Department heads, academic counselors and advisors, intervention specialists, and others with similar responsibilities. So that's not a lot to go on. But I think the point that you both have made, which is the valid one, is the institution's going to have to really demonstrate that they view the co-curricular activities as a crucial part of the academic process. The more that you can show that, you know, your mission statements, your announcements, your pronouncements, that's how you begin to build your case. Yeah. But remember, too, one of the risks in this area is you're going to have either an investigator from the Department of Labor show up on your doorstep one day, or a lawsuit show up on your doorstep one day, and those are going to be people who have no understanding whatsoever about how your institution operates, what its core functions are, what its core values are. And so this is an area, though, where I think careful advanced planning, outside counsel always likes to say, if we can build the facts of the case before the case gets filed, that's the best position to be in. And it's going to go to, how do you express, Rosie, the points that you made, and how do you demonstrate all along that we view this as important, as an important aspect of the academic function.
So the administrative exemption that we've just been talking about that uses the word academic, is there any reason why y'all think that we should presume it only applies to staff who are attentive to the institution's own students? What about outreach programs, upward bound types of programs that have an academic component to it, or are maybe at the other end of the spectrum, lifelong learning programs for alums? Are those fairly within the academic administrative exemption, do we think? Is there a case to be made for it, at least?
Well, I'm not touching that one. I'm not touching that one. That's a good question.
It's you know, I think those are the kinds of questions we're going to have to sort through. I don't think we're going to get clear guidance. I think that organizations are going to have to figure through their own thoughtful processes whether they can make a business case that is the case. I think there probably will be institutions that will make very compelling cases in that regard. There may be other institutions that will take a pretty conservative approach and say, if it isn't on that list of 4 things that Steve just read off, that we're not going to trust that we can make that assertion. I don't think there's an easy answer to these questions. I mean, we do have one hint in some of this guidance, which is around athletic coaches. Mm-hmm. And what the paper that accompanied the release of this rule, there was a paper provided by the Department of Labor for institutions of higher ed. And one of the things it said with regard to coaches, and coaches were one of the areas of real question for higher ed, was that if the coach is in the business of instructing in their sport, even if it's not for credit, essentially, that there may be a case to be made that they meet the teacher exemption. So that provides a little bit of a hint, I think, about where DOL may draw lines, that it doesn't necessarily have to be for formal academic credit toward a degree. It may be read a little more broadly than that, but I don't think we've gotten much guidance, and I don't think we will get much additional guidance on what other programs might be acceptable.
So,
well, let me just ask this, though. And I've heard some colleagues say that they want to use that coaching example, but in your question, you said, what if it's teaching alums or teaching upward bound young people are in high school.
That are not students
They're not
of the
students.
institution.
And so
Yes.
the example with them working on the campus and using the coaching example, I can see. But I get stumped by, and if they aren't on the campus, I mean.
Yeah, I don't think there are answers.
Having said I won't touch it, now I will.
Yeah, now you will.
And again, it gets back to what's the mission, what's the stated mission. If the stated mission of the institution is academic in a broader sense, we are not a for-profit institution where all we're interested in is educating this student. We believe we have a broader mandate to reach out to the community, which would include upward bound students, to get them a slice of life, let them see what academia looks like, alums, get them back in, retirees. If that's part of your mission and you express it as such, now you've broadened the definition of academic, and maybe you can
Maybe
fit
you
it.
could make a case.
So the interesting thing about the question I posed that's caused us to chat for the last few minutes is that that's a question from the viewing audience. And that shows us just how in the weeds and situation-specific folks are going to be taking on these, for them, new sets of questions and
they
trying to answer
They
them.
should be.
The coaching exemption. If I'm hearing this right, and I paid attention, Steve, during your comment about this at the front end, if I'm a coach whose sole responsibility is breaking down film, I'm probably not fitting within the teacher exemption.
I think that's right.
If I'm the women's lacrosse team's goalie coach, and I'm out there every day with the goalie, but I'm also breaking down some film for the goalie, I'm probably fitting in the teacher exemption.
The issue, the answer, Peter, is what is the primary responsibility? There is no bright line statistical test. Frankly, one of the things we thought when the new rule came out, one of the concerns we had was that we were going to get a bright line definition of primary, but the DOL did not do that. So there are cases, clearly, arithmetic says if 51% of the coach's time is on the field with the goalies, I'd say that's the primary function. The case law has not gone that far, and it can be a primary function at less than an arithmetic 50% number. But if you want to be safe, 50%.
So I want to marry these things to the academic administrative discussion we had a moment ago. Whether one is a coach or an academic administrator, one still needs to be paid above the minimum level for a teacher, an entering teacher or a teacher at the institution. Help me understand what those terms mean. Help me understand how at a place like Vanderbilt or Memphis, that has multiple schools and levels, help me understand what that means. What are we talking about when we say an entrance salary for teachers and you got to pay somebody at least that much?
And it's the average.
It's the entrance level for a teacher.
It's the entrance
Yeah.
level.
And the answer is, who knows what that means? My guess would be that as the DOL writers were thinking about this, they were thinking about full-time teachers, full-time faculty. It doesn't necessarily have to be your tenured or tenure track faculty, but I think it would be hard to make a business case, frankly, if you said, well, we have adjuncts that we pay $5,000 a semester, so I guess that's our threshold. I think it would more fall in the line of what other full-time academicians make, and if your academic administrative folks are making at least that same amount, then they may fall under the exemption authority.
Yeah, Barbara is correct. The DOL has offered precious little guidance here. The rule of thumb that I take away from the new rule, as I already recited, is they believe more pay for workers is good, cost to employers we don't care about. So it is a risk-reward continuum, but I agree with Barbara. I would be concerned about using adjuncts as the entry-level baseline. I think the safer approach would be full-time faculty, and if you want to be really safe, full-time tenure-track faculty.
Yeah, and I would say that given all of the discussion and all of the discord that's gone on around adjuncts over the last several months, I definitely would not go there. Some of our institutions haven't increased adjunct salaries in decades, so would not do that. I would say minimally, and I would ask a group of people to talk about this. We were talking about full-time, the base level on campuses is generally instructor level, so nothing lower than that. And maybe people want to consider assistant professors, but I definitely think we're talking about full-time workers, not adjuncts who are not full-time.
So if I'm thinking about process in the summer of 2016, this sounds like one of the questions at the top of the list among the groups of individuals who are attending to this on a campus. Figure out what is that minimum salary that must be paid to somebody who you're going to be applying an academic administrative exemption to. Don't leave it to the provinces around campus to have different answers to that singular question.
Probably prudent to have a campus-wide defensible approach.
And they did say average salary, right, Stephen? Because different disciplines start their faculty at different prices.
I think it's at entry.
That's
I think it's at
interesting.
entrance
I think
level.
it is
I know it.
entrance. It's, yeah.
Entrance level, but an
question.
entry-level business professor makes a different salary than an entry-level English professor.
I don't think that was actually addressed in the.
No,
in the-
clearly wasn't addressed.
So,
That's a
so
great
if the
question.
three of you were on one campus, sitting down, having this conversation, I understand part of the conversation. But it doesn't mean that you can't and shouldn't come to an answer about it, right?
You should come to an answer.
Yes.
For your
yes.
campus.
Because the campus has to take the risk and the
Be-
final analysis.
Because the campus has tapped that person on the shoulder, has said, we dub you exempt.
Right.
We dub you as fitting within this category.
That's correct.
And this is the minimum salary that we believe we're obligated to pay you. Is
And
that
it-
how it
yeah.
works?
Yep.
And as an HR person, I will tell you that I don't think that's an HR decision. That's an academic affairs decision.
Okay, so let's stay in the student affairs world for a moment, and let's return to something you touched on a bit, Steve, as I recall. And this is other forms of compensation that one maybe not think of as compensation, but the institution does. And I have in mind housing. I'm either asked or required, or I never thought about it, I just know I have it. House on campus. I'm either asked, required, or I never thought about it. I have the ability to go into the dining hall and be fed. Can the value of that in any context be put into the mix when figuring out whether I meet the minimum salary threshold?
The answer is a flat no. In order to meet the salary level threshold of $913, no credit is given for room and board. So easy answer there, bright line test. Now, if an institution decides we have people who we are currently treating as exempt, we make the decision not to increase them to the new minimum threshold. For non-exempt employees, you can get a credit for room and board, provided that the primary beneficiary of that benefit is the employee, not the employer. So, for example, a meal card for free lunch at the cafeteria, I think an employer can take a credit for that for non-exempt workers, because that's clearly for the workers'
What do you
benefit.
mean a credit?
If you are figuring out how much somebody's going to get paid, you're going to be paid $40,000 a year, doesn't meet the threshold. Of that $40,000, we're giving you a meal card that's worth $1,000, so we're going to give you $39,000 in your paycheck. That is probably appropriate in most circumstances.
And would you also, it seems to me, be imputing that income of $1,000 to the employee and have a taxing consequence?
Yeah, I would think,
Likely so, yes.
I think you would have a tax consequence, but, good question. I'm not sure that you would have to pay overtime on the meal
meal
credit, on the meal card.
So this flags a practical bottom line answer to a question that I'm sure many people around the country have. No, $47,000 is $47,000 cash in terms of the floor salary that's necessary. If you have a requirement a practice of providing room and board. It may have other implications,
Right.
but it's not going to help, if you will,
That's
on this
correct.
issue.
Right,
That's our understanding.
correct.
And I'm not hearing that anybody's sounding like there's room for debate on this or cleverness.
Well, there may be cleverness in that. For some of those live-on jobs, maybe you want to change them to student jobs, because there are some regulations about how one pays a student. And so it could be that you go to having more training for students and let them get more experience for their next job and not have that as a regular full-time
Staff
worker.
job.
Yeah.
So a few minutes ago, the phrase part-time was used in a different context. I want to turn our conversation very, very squarely on the part-time employee, the part-time faculty member that exists on probably every campus in America. My question is this: if I am a part-time employee whose full-time equivalent salary would exceed $47,000, but my actual salary is roughly in the range of $30,000, how do you think about me for the salary test?
You know, I've considered that. You have a, you know, distinguished emeritus faculty member who's, you know, won a Nobel Prize and, you know, is retired but still working in a lab, has a lab or has some programmatic work that they do 10 hours a week or on a quarter-time basis. It would be ridiculous to think that we would have to track that faculty member's hours and conceivably pay them overtime. But the answer is we have to track that distinguished faculty member's hours and conceivably pay them overtime. The threshold is $913 a week, period. It does not, it cannot be adjusted or prorated by FTE. So it's a hard number, $913 a week. If you're paying less than $913 a week to an employee, regardless of what percentage of effort they're putting in, they become subject to overtime if they exceed 40 hours a week.
Yeah, we talked about this earlier, Peter, and it's interesting. In academia, there's really two kind of definitions of part-time. The traditional definition of part-time that applies in every workplace is someone who is scheduled to work less than 40 hours a week. And as Barbara said in her example, if you have a full-time faculty member who is on a reduced schedule with reduced compensation, if he does not meet the salary level test, or she, of $913, they are overtime eligible. Now, because they are part-time, presumably they're not working more than 40 hours in a week, and so there's no issue there. But in academia and higher ed, I know some institutions view part-time as someone who teaches one semester a year. That person, the salary level test is weekly. It's not annually. So you can't take $47,000 a year, prorate it to one academic session and say, okay, now the person is exempt. They have to be at $913 a week, every week.
Every week that they work.
Every week that they're working.
So many who are joining us around campuses either are or work with folks who are 10-month employees, maybe 11-month employees. Help me understand what this means for them.
So
I'm sorry.
if the individual really does work 10 months and they have 2 months where they perform no work at all, you need not pay them during those 2 months or 3 months in the summer. But the months that they are working, every week they have to hit $913 a week. So the real rule is $913. It's not $47,476.
Sure. So I am hearing that there could be a $45,000 or $46,000 annual employee on a 11-month or 10-month contract who is going to actually meet the salary threshold.
If they perform no duties whatsoever during that time off. So if they come back and do other stuff, or they serve on committees, or they prep for the next semester, then you have a problem. But if they're performing no duties at all during the months that they're assigned off, then you don't have to meet that threshold for that time.
Can I spread my salary out over the 12 months?
You know, that's a good question, and a lot of institutions do that. They'll have 9-month faculty that they pay over 12. To the best that I have been able to determine, that's not prohibited here. It may be how the pay is delivered and not how the pay is earned. But that's an area where we're going to have to make sure that we understand, because a lot of institutions do that typically for the purpose of being able to deduct benefits during summer months.
Or the person really wants it because they want the income to just be,
Right.
yeah.
Well, remember, rule number one, if the person wants it, it doesn't matter.
I know, you said that.
But that's a very interesting question. My concern would be, the new rule is so very clear, as Barbara has said, in saying $913 per week. If you are going to take it and spread it so that now it's less than $913 a week, I think it's going to have to be made very clear that we're going to pay you in August and you are doing no work. And we are doing that solely to maintain your benefits. It's it's a payroll
It's a delivery
function.
of pay,
It's
not an earning of pay.
But I'm not even sure that
Yeah.
that's going to get you across the
I think
finish
that'll
line.
be a topic that we'll continue to sort through.
Now, this gets to the question of required work versus I am interested in my career. I am interested in showing up the next day and doing a great job. I do things that nobody has asked me to do. I just want to do them.
The legal answer is sadly crystal clear. The legal standard since the 1930s, when the Fair Labor Standards Act was passed, was suffered or permitted to work. That doesn't say directed to work. It means suffered or permitted. I allowed you to work. The example I always give is, my secretary says, Steve, I love my job. I love my job so much, and I love working for you so much. Neither of those things are true, by the way. That I know it's my lunchtime. I know I'm not getting paid. I'm just going to sit at my desk and do my work because I love it. If I know that's going on, the only way I can avoid not paying my secretary is to handcuff her in the lunchroom. Literally call security and remove the person from the workplace. But, extreme example. The honest answer is, if management knows that that work is being done, it is compensable.
That's correct.
And what the Department of Labor regulations say is, you can discipline the employee for doing that, but you must pay them. Now, that seems to be an absurd result, but that is clearly the result.
So let's transpose that onto a typical college campus, where folks have been known to use email once or twice a day. I send an email as a manager because it's my nature to do this at 6 o'clock or 9 p.m. or whatever, not expecting but also not minding if somebody who works for me responds before I show up the next day. Now, Rosie, in your environment, you're going to have some folks who have been thinking and acting as exempt, who will now be not raised to a salary level that permits them to continue that way, and they'll be asked, or to Steve's point, told, don't be going off and working overtime. Are we saying that we don't want and can't tolerate that email being prepared at 11 o'clock at night with the button pressed?
I'll give you two examples, and this is an area that we're now seeing litigation over. There's a big case in Chicago about police officers checking their BlackBerries after hours. One practical observation is that we have certain administrative support staff in my law firm where if you email them after 5 o'clock, the bounce back message is, I work 9 to 5, and I will not be reading this email until tomorrow morning at 9 o'clock. So one option is lock people out of the system. If they are not exempt and you don't want to pay them overtime, the email can be sent, but, and again, I don't know anything about tech, but I'm assuming that you can lock someone out of their work account during the times that you don't want them working. Now, that may be an extreme example, but it can be done. What we've seen in the cases, in particular the Chicago police case, was the court said, so long as the employer's policy is you are not obligated to check your emails after hours, we are not telling you to do that, our policy is quite to the contrary. If someone does, and all they're doing is checking for a de minimis amount of time, not compensable work. However, if the police sergeant looks at it and sees terrorist bombing at a nightclub at 11 o'clock, all hands on deck, well, now the clock goes on. Now I'm on the clock because now I'm doing work, and maybe that's 30 minutes or an hour or 8 hours. But it seems to be that the courts are moving towards a common sense approach, where if against company policy I'm checking my BlackBerry for a couple of minutes at night, not compensable.
And Steve, I think, isn't DOL actually working on some guidance on media? I think they may have some pending, yeah, so we may get some guidance.
So a non-media but related question from the viewing audience. I'm just going to read it to you. At our institution, non-exempt employees have been asked to volunteer to walk in parades this summer to advertise our college. It is not a requirement of their job, however. Some of them do work, for instance, in the admissions office, and that's part of their goal. Would the time they spend walking in the parade be counted to determine whether they should be receiving overtime that week?
Yes.
Suffer and permit.
Yeah.
Yes.
Well, although surprisingly, I may not, the analogy I'm thinking about is, there've actually been guidance from the DOL about the high school teacher who on Saturday helps direct cars to the parking lot for the football game. That's been deemed to be a volunteer function.
Even if they're required to do it?
No, if you're required, no.
Okay.
Yeah, you're right, Rosie. Anyone who's required to march in the parade, that's work. But that that example is right to the edge, because, for example, if the school says on Saturday, we're sponsoring Alex's lemonade stand, and any staff who wants to participate may participate, I do not believe that is compensable. I think that is properly volunteer work. That one's real close.
Yeah, because if you're asking them, would you please volunteer?
Right.
I don't understand how that's volunteer work.
Yeah. That's
Although,
the fine line.
I've looked at the issue of an employer that says, we have a partnership with Habitat for Humanity, and we are going to commit 1,000 hours of community service to Habitat for Humanity, and employees are encouraged to go. I still don't think that's compensable.
I find that different, though. If you write a general email or communicate in some general way to the faculty. This said, I want the admissions counselors to march in the
volunteer,
parade,
yeah.
to advertise our college. They're
Yeah.
recruiting. And so that's why I wonder if
Yeah,
that's
I would be
right
more
on.
circumspect about that one.
I would be too. But I would not if we had a general communication to the campus saying, there's a volunteer opportunity for Habitat for Humanity. If you'd like to go, great. In my mind, that's very different. It's not
Yeah.
a specific group of people. It's open.
Volunteer versus being volunteered for.
Yes.
And Peter, let me just close the loop here. One concept that's very important. You cannot volunteer to do your own job. And you cannot volunteer to do someone else's job, even if the person really does volunteer. No, that's compensable work. This parade is, and where I'm struggling with it is, it's kind of a community-based function. So there's a work aspect because they want to get the name out, but it's a parade. that's what makes this one a real interesting question.
So let's stay with admissions, and let's broaden that out to travelers. Alumni relations travelers, development travelers, staff who are going ahead of conference attendees or folks who are putting on academic conferences. All of the stuff that doesn't fit squarely into 9 to 5 and also doesn't fit squarely into a non-9 to 5 schedule. And we just can't schedule you for the night shift on this stuff. How do we think about what's compensable time requiring overtime if you don't meet the salary threshold?
So if you don't meet the salary threshold and you're therefore considered non-exempt, the rules around travel and on-call and areas like that are actually fairly well defined in existing regulation. So you would be subject to the travel rules. If you're traveling during what would normally be your working hours, clearly compensable, but then there are other circumstances where if you're driving the vehicle, even if it's not during your regular business hours, it may be compensable. If you're attending an event at a conference in the evening on behalf of your employer, it may be compensable. Those rules are pretty well outlined in current regulation, so I would suggest that people take a look at the travel rules and related rules to understand how that may impact those folks. That said, I will say that people aren't entitled to an 8 to 5 schedule. So if you know that somebody's going to be working an evening or a weekend, you can adjust the work week to keep a 40-hour schedule, but not necessarily be a standard institution-wide work week. So,
And the other point is, too, for non-exempt personnel, if it's a job that's going to require a great deal of travel, and I'll leave aside the HR morale aspect to this, but you can pay someone a different hourly rate while they're traveling. When you're at your desk, you're making $30 an hour. When you're sitting on an airplane, we're going to pay you $15 an hour. Now, that raises all kinds of HR issues, but
Logistics
legally, that is permissible.
So a question from the viewing audience. Let's house it in the admissions office because it makes sense. Let's give credit to imaginative thinking in practical circumstances. The question is essentially this. What if I'm paying $913 a week for lots of weeks and $913 and less than $913 for other weeks? Can I be paying overtime for just some of those weeks and not paying overtime for others? And, we get it, right? It's really busy in an admissions office between September and April, let's say. Less busy, perhaps, between May and August.
I think the answer is that's permissible. Now, I'll leave the HR morale and logistics issues to Barbara. But as we've said several times, the exemption from overtime is determined on a week-by-week basis. So, for example, if someone is making $913 a week and they take a sick day and the employer dings them, or they say, hey, we don't have enough people this week, you stay home on Friday, and I'm going to pay you one less day. Well, the employee gets overtime for that week. They have lost the exemption for that week. So given that, I think that you can say, and make it clearly agreed, in the summer, I'm going to pay you $700 a week in the admissions department, and during the academic year, I'm going to pay you $913 a week, and that's probably okay.
as long as you're at least paying the federal minimum wage, the feds don't set you must pay this amount every week to an employee. That if you're paying less than $913, they would be non-exempt for that week.
Switching gears a little bit, Rosie, Barb, we have a person from a public institution, a person from a private institution. One of the things that's been floating around as either accurate statement of the law, Steve, or lore is comp time. Can I give somebody comp time in lieu of overtime? Once I've figured out that this person isn't going to be exempt, the person's going to be non-exempt. Can I give them comp time even if they want comp time? And one of the things that's been floating around, I think more the law and less lore, is it matters whether you're public or private.
That's
I'm throwing
correct.
this on the table. Let's talk about it.
That's correct. I can give comp time. She can't.
That's right. State and federal aid, or state and local government, government entities, public entities can provide comp time at time and a half in lieu of pay and at time and a half. Private employers cannot.
And I like it that we can give the comp time, we can have people work September, October, November, and save the comp time to December.
Yeah. Now, in the private sector, and this is an exception, but it's so small it really doesn't matter. You can give comp time during the same work week.
Yes.
Yeah.
So in other words, if someone works 12 hours on Monday, you can have them work 4 hours on Tuesday, because at the end of the week, they're still
So
at 40.
adding up to 40.
But obviously, everybody is correct. Comp time does not exist in the private sector.
So let's stay with the non-exempt employee, the person who has to get used to the new world because he or she last term was exempt. And he or she does do these little bits of responsive things at night or otherwise, sometimes a lot, not just a little bit. Is there any kind of a de minimis rule that's applicable here? And this is a question from the viewing audience as well. How are you going to instruct people about when an email response to the boss that says, I'll look at it in the morning, is okay and doesn't need to be compensable, but 7 sentences that conclude with, I'll look at this further in the morning, isn't?
The answer is, as I mentioned before in the Chicago police case, the court in that decision said, yeah, there is a de minimis standard here. And if you're just checking and if you're just responding and you're at home and otherwise you're engaging in whatever life activities you want, that will not be compensable. But there is a line to cross. And the other concern I really have in this area, and we talked about this before we went on camera, is there is so much litigation today prior to these rules where the employees are arguing in court that we were required to work off the clock, either by way of formal policy, or even if the policy says do not work off the clock, my supervisor came to me and said, punch out at 5 o'clock, I still need you to get these tasks done. That is the risk of having people respond, because a disgruntled employee, Lord knows I've seen it in many, many wage and hour lawsuits, the disgruntled employee who spent 5 minutes each evening checking email, if they get fired and if they file a lawsuit, they will say, I spent 2 hours each evening checking email. And how do you prove that? How do you stop that? I was forced to work off the clock will be the claim. That's the risk.
So I'd like to move squarely into the academic / research arena on campuses. And I'm imagining that this set of issues that might be thought about one way at a Vanderbilt or a University of Memphis can be transposed to different segments of a higher ed community at a community college. And it goes like this. We talked about the teaching exemption earlier. I want to talk about postdocs. I want to, make sure we all understand what we're talking about. And then I want to talk about the distinction between a postdoc who can't be claimed to be a bona fide teacher and all the other postdocs. I'm going to start with you, Barb. I think you've been thoughtful about this at Vanderbilt. How are we thinking about postdocs in this new world if we presume for a moment that not all of them in the country will be raised above the salary
Yeah.
threshold.
We have been doing some thinking about postdocs. It's a group of 500 folks on my campus, so it's a population worth talking about for sure. If teaching is a primary duty, then they may well fall under the teacher exemption and the salary threshold would not apply. Most of our postdocs, teaching is not a primary duty. They're primarily focused on research. They will be either need to be paid if they're working as an employee for the university. They'll either need to meet that $913 threshold, or they'll need to be treated as overtime eligible. And it's not work that I think anyone would say would be conducive to hourly tracking. It's intellectual work. It's if you're running labs, you don't just stop at 5 o'clock. It's very difficult to wrap your head around, but I think the real challenge for research universities, in particular with that group, is figuring out ways to try to hit the threshold for those kinds of positions so that they don't revert to a non-exempt hourly tracking process.
I think there is another group of postdocs that sometimes we deal with in student affairs in particular, and that would be a psychologist, someone who has their first year out as a psychologist. They're a postdoc and not making the same beginning salary as a regular psychologist. I think that we're likely to say that you're overtime eligible. And so the rub will be having those individuals and having us have to keep track of time. And so that is the psychological impact that I sometimes talk about too with an individual like that, or some of our staff, our regular staff, who actually are now, by this rule, overtime eligible, but they believe themselves to be exempt employees, and the psychological cachet that goes with that is important to them. And so I think we'll have to find a way to say to them, yeah, we'll have to make a cultural shift there. The only thing I'll say, and I'll say this for our viewing audience too, in case some of those young professionals are out there, that at least it's happening all across the country. It's not personal.
So this is exactly why I prefaced my question with a reference to community colleges, is a postdoc could be considered on some levels an intern. There are many areas around our campuses, from community colleges to major research institutions, where there are professional interns, called that or otherwise, but they're playing that role, and they're not going to meet that salary threshold. Are we essentially saying that there's no way to get around the fact that they're going to be non-exempt employees and asked and managed in terms of the overtime issue?
I think that's correct.
I agree. And this discussion leads to a very important point. Record keeping for purposes of the FLSA is crucial because it is the employer's legal obligation to accurately track hours of work. The employer's obligation, not the employee's. Now, the DOL doesn't prescribe any particular form of record keeping, but the employer must maintain accurate records. And the downside is, if the employer does not, the case law is clear, anything the employee says will be adopted as true. I tried a case with a restaurant years ago where the boss kept no time records at all. It was a very high-end place. People were making tons of money in tips. He didn't pay his people at all. They were making $400 or $500 a night in tips. He didn't pay them the $2 an hour minimum wage, and he got banged. The problem was, because he kept no time records, he had people come in, and for a restaurant that was open Tuesday through Saturday, dinner only, he had people testify in court that they worked 120 hours a week. And the judge accepted their testimony because he had no records. So that's the real risk in academia, as Rosie has said and as Barbara has said, in taking these postdocs, for example, who don't keep time records and work irregular hours anyway. They wake up at 3 o'clock in the morning with a brilliant idea and go to work, right? how institutionally you now impose your legal obligation to keep accurate time records is going to be a real challenge.
I will say, Peter, interns are kind of an interesting question in my mind. If the intern is a student enrolled in an academic program and maybe assigned to an internship experience, there may be some considerations where that person isn't necessarily considered an employee. So that's a good question, and I think it's one that we should talk about. How to articulate if there's any wiggle room there.
But does it change if they are, an internship is a requirement in order to get your degree, but you're working at a different institution?
That's the question.
Yeah.
So let's go to students again on a slightly different level. Steve, you mentioned at the top of this discussion that the Department of Labor doesn't think about students as employees for purposes of this wage and hour issue, even if that student gets a paycheck.
Well, fine line, good point. It's better that we really make the terms clear. A student employee who goes to work at the bookstore is an employee, must be paid the minimum wage, must be paid time and a half over 40. The examples I gave were student teaching, where if under the guise of a professor and required for their academic program, that is probably non-compensable time because that is part of the educational program. Same thing with student resident advisors, the old hall counselor. You don't have to pay for that. They're students, they're in an enrollment. The fact that they're acting as hall counselors, you're okay. But once you have them, and it's really kind of a common sense test, once they're doing real work, that if it wasn't for the student being paid $10 an hour, someone else would be paid $10 an hour to do that job, then they're employees.
So let's take graduate students who are compensated and have for some level, and I use that word to recognize that there's some portion of what they're receiving from the institution that the IRS would view as compensation. They're being paid, or they're receiving some level of benefit, and I'm not going to define those words, but that's the graduate students we're talking about. And a subset of them at some institutions might even be unionized. How do we think about that group of folks this summer as we ask ourselves on our campuses whether we need to be instructing them and the folks they are advised by and work for about how to live their life after December 1 on our campus?
Well, the rule and the white paper that the DOL issued for higher ed does speak to graduate research assistants and graduate teaching assistants. So I think there is some guidance there. It doesn't speak to union, non-union, and I think that for states where, and there are a few states at least, where there would be unionized graduate students, you also have to stack those considerations, the union provisions of the union contracts, on top of the federal guidance as well. So it's not like one offsets the other. You're going to have to look at both components.
But as Barbara said, for purposes of the new wage and hour rule, the real key is, are they teachers or are they researchers? If they are teaching, then the teacher exemption applies, and with it, the evaporation of the salary level test. If they are researchers and not teachers, then they are covered by the professional exemption, which carries with it the $913 an hour minimum.
Actually, the graduate research one, the Department of Labor has said that if they're conducting research as part of an academic program under the guidance of a faculty member, for example, that they're not going to assert that those are employees.
One of the things that I just want us to make sure we're clear about is that this isn't saying that we have to pay everybody that amount of money or a certain amount of money, but that they are eligible or not eligible for overtime, so that people don't all have to go out and raise their budgets, but they have to say whether or not one is eligible for overtime or not. Because there are graduate assistants who do none of that, and so they may be now overtime eligible, but they will make about the same salary. One question I had for you all is, what about paying tuition for the graduate student? How does that count? Is that part of, can that count as part of what their compensation is?
That's a good question. I'd probably want to test it, but I think the short answer is kind of like housing, which is it essentially doesn't count. It's like one of the questions I've seen raised, and the Department of Labor did answer on employees, was would the provisions of a benefits package, health care coverage or retirement contributions, would those count toward the 913? And their answer squarely with regard to employees and benefit value was no. My guess is that tuition waiver, that's essentially a form of scholarship or financial aid, probably would not also count toward the threshold. But I don't want to make that as a definitive statement. I think that's something that would be worth following up to confirm.
Peter, I want to go back to the point that Rosie just made. We've spent this whole time talking about what the problems are and what the areas are. We haven't spent a lot of time talking about the solutions. And the solutions are pretty straightforward. The institutions can either raise people below the 913 level up to 913, in which case they receive no overtime. The institution can say, I'm not going to raise them from their current salaries. What that then triggers is either an institutional decision that these people will not be permitted to work overtime, in which case the dollar expenditure is the same, or you will pay them time and a half for overtime based on a calculation of an hourly rate based on their salary. The last alternative, and the DOL does say that this can be done, although as we were talking about before, from the institution standpoint, it raises morale and logistical issues. You can back into the current number. If someone is currently making $40,000 a year as salary, not being paid for overtime, their salary can be reduced to a number that when you do the arithmetic and plug in the overtime hours that you expect them to work over the course of a year at time and a half, at the end of the day, it's a zero-sum gain. They are at $40,000. So those are basically the options for coming into compliance under the new rule.
Steve and Barb and Rosie, we've had, I think, a robust conversation that hopefully the folks around the country are relating to. I really appreciate that, to your point, Steve, a lot of this has been about issue spotting and solutions and concern about culture. In the last couple of minutes, Steve, though, it would be helpful to just touch on the worry, the risk, if you will. What is the potential exposure of an institution if, despite everybody's best efforts, it's not working out so well?
Sure. Under the Fair Labor Standards Act, there are 3 remedies for violations. Number 1, back pay for unpaid overtime. Number 2, liquidated damages if there is a lawsuit, liquidated damages in an amount of the back pay. So basically, it's a double damages statute. If it is an audit conducted by the Department of Labor, there are fines and assessments that come with the back pay award. But if there is litigation, it is a fee-shifting statute, which means the employer then pays the fees of the employee's attorneys. The risk in this area is less so the one-off violation. If someone for 1 week or a couple of weeks doesn't receive the statutory minimum, doesn't receive the proper overtime, that's a risk, but it's not a huge risk. The risk in the area of wage and hour law is right now globally, this is an area of the law where there are more class actions than in any other, certainly in the employment law sphere. And those are very expensive propositions because now your plaintiff class is not 1 person, 5 people, 10 people, it's 100, it's 250, it's 500. And the back pay then becomes substantial and the exposure to attorney's fees becomes substantial.
So with that in mind, in the last minute, Barb, Rosie, going back to your campuses, what are your thoughts about how you engage your senior colleagues and the folks in your spaces to pay attention to this? You know, what's the line or the sentence or the statement?
Well, I think we have got to say something in the email that we're going to send to all of them that gets their attention. But I think the thing for us to do is to call those people together and not only involve the senior people, but I actually think we've got to involve all constituents. And I think that's a combination of media and a combination of town hall meetings.
Barb, the last word.
I agree. We've been doing, going out and meeting with managers, with senior leaders. We've been talking to them about the specifics of their scenarios, and we've been engaging them in helping understand and solve the problem. I do think that substantive discussion is helpful, because I think it gives the opportunity for people who may not touch this kind of stuff very often to really wrap their brains around some of the illogical aspects of the crazy, that couldn't be possibly be true kind of conversations. And it's helpful if you can have those face to face and not just get an email that makes doesn't conform with, you've got a PhD, you're logical, and that doesn't make any sense, so it must not be true. We don't attribute a lot of logic sometimes to what gets implemented in federal law and policy. So it does help if you can talk about it with leadership and work through it together.
Well, thank you for talking to all of us and to our colleagues around the country. I wish you a very happy and enjoyable weekend, and the same to everybody else out there.